Is Mr. Wood still online? I saw Mr. Wood earlier.
Judge, I am.
All right, can you turn your video on by chance?
I sure can.
All right, this is cause number CR19-124, CR19-125, State versus Jeffrey Lynn Warner. And we were here on status of attorney. I see Mr. Sandell is here. The court has granted the motion to substitute counsel, Mr. Wood for Mr. Sandell. And Mr. Sandell, I appreciate you joining us today. I really wanted to have you here so that we could be assured that any transfer of discovery would be able to be accomplished between your office and Mr. Wood's office so that Mr. Wood is not delayed in preparing for trial for Mr. Warner's case, which has been specially set for trial later this year.
Of course, Your Honor, we've already got that on a disk or a flash drive, so I'll reach out to Mr. Wood today and see if he would like us to mail that or if he'd like to swing by and pick it up. But whatever is the most efficient, convenient way for us to get our files over to him, we'll be happy to do it.
All right, thank you, Mr. Sandell. All right, so the court having granted that, I don't already specially set for jury selection, so I don't know that we need any further settings in this case at this time, unless you're aware of something, Mr. Wood.
I'm not aware of anything, Your Honor.
Okay, all right, then let me just check his case real quick so we can put on the record when in fact he's set to appear before the court again. Well, of course, my computer's not going to be responsive at this time, so I'm not going to.
Judge, I show it to be November the 30th.
Do you show any other docket settings between here and there?
I just have the special set trial list through the end of the year, and that's the special setting.
All right, then, Mr. Warner, you're ordered to be back here on November 30th. Is that correct, Ms. Heisel?
Yes, Your Honor.
All right, at 8:30 in the basement of the courthouse. And if anything changes, of course, you'll be notified by the court through your counsel, Mr. Wood.
Yes, sir.
All right. All right. Thank you, gentlemen. That'll be all in this hearing.
Thank you, Your Honor.
All right, counsel, do we have anyone else that's ready to go? Mr. Schmidt? Weldon Lee, CR 20-84. Come on up to the podium, Mr. Lee. I believe that Mr. Lee is set for pretrial. Is that correct?
Yes, Judge. I'm not certain if he's been arraigned. We have received the indictment. His next that he hadn't been arraigned, he's not guilty. I don't recall filing a waiver on that, and I didn't see it. Over 20 June.
And Mr. Schmidt, I can't tell from the clerk's record if he's been arraigned or not. So let's just go ahead and walk through that. All right, Mr. Schmidt, I've had the indictment for CR 20-84 displayed on the screen here for Mr. Lee's benefit. Can we ensure that his name is spelled correctly in the indictment?
It is, Judge.
All right, does he understand what he's charged with?
He does.
And how does he enter his plea?
He was a plea of not guilty.
All right, court will enter Mr. Weldon Lee's plea of not guilty into the record. And we were set for pretrial today. Do you need an additional time for pretrial, or do you believe you're ready on that?
Judge, I was aware you said pretrial. I talked to the DA's office yesterday. I am requesting one time, and then additional pretrial setting. I would ask the court, back on several cases on September 29th, and ask if this night is it's okay.
Any objection from state? You're muted, Ms. Heisel.
No, Your Honor, I'm having a hard time hearing Mr. Schmidt, but we did speak yesterday and agree to a reset on this. I just need to know what the date of that reset was.
September 29th.
All right, court will grant the defense request for pretrial setting on September 29th. I've changed microphones, Ms. Heisel, perhaps that'll be better. We'll just ask counsel to make sure we speak up as loud as we can so that this microphone can pick you up. All right, court's going to take up cause number CR 20-88, Pedro Manuel Perez. And I see Ms. Cazares Perez, you're online via Zoom, is that correct?
Yes, I am, Judge. Good
Is
morning.
your client present via Zoom as well?
Yes, he is. Pedro, can you please unmute your microphone?
Yes, hello, I'm here.
Okay, good. All right. Record will reflect that the defendant Pedro Manuel Perez and counsel are appearing via Zoom today. And I understand, Ms. Cazares Perez, that there was a motion for continuance to be filed, but it was filed 48 hours before today's hearing, so the court was not in a position to be able to take that up with notice to the state. So the court denied that motion for continuance. We're set for pretrial today. I understand through your motion for continuance that you have had the discovery. You as counsel have an opportunity to review that, but I understand that you have not been able to meet with your client about that. But were any pretrial motions filed 7 days prior to today's hearing?
No, there have not been any motions filed.
And do you anticipate the filing of any contested pretrial motions, motion to quash, motion to suppress?
Not at this moment, but I would like to, if I would have an opportunity to review the discovery with my client and get a little bit of more information from him. I would just like a little bit more time to have the opportunity to do this.
Any objection about state?
No, Your Honor, that's fine.
All right, and what we'll do is we'll set this for an additional pretrial, and we set this for September 17th. Do you have any scheduling conflicts that day?
I had spoken to Mr. Cox on this, and he had agreed for us to pass it to September 29th. Would that be okay?
Yeah, that's fine.
Thank you.
All right, court will set this then for pretrial on September 29th. And you have received all the discovery from the state, is that correct?
Yes, I have, Judge.
All right, then Mr. Perez, you're ordered to appear on September 29th for pretrial. And if you need to appear via Zoom, you'll need to contact the court and make arrangements for that.
Yes, sir.
Ms. Zares Perez, I'm going to tell you that at some point we need to have Mr. Perez booked in and out of the Van Zandt County Jail so that the state of Texas can attain a tracking number for his arrest. I believe he was arrested out of county. So it'll just be a book in, book out process. He's going to need to be in Van Zandt at some point to get that done.
Okay, Judge, I will arrange for that.
All right, there's nothing further in this hearing then the court will adjourn this hearing and we'll see you back on September 29th.
Thank you, Judge. May we be?
Yes, you may. Thank you.
Great. Thank you.
You're welcome.
Thank you.
All right, counsel, we have anyone else that's ready?
Your Honor, we're ready.
Ms. Dixon.
Yes, it's Zion Thomas, Your Honor.
CR 1876, Mr. Thomas, you'll make your way to the podium, sir. I believe that we reset the hearing today. My docket note indicates that Mr. Thomas was trying to get caught up on his community service restitution.
That is correct, Your Honor. And as of today, Mr. Thomas has not yet completed that. He continues to have some issues regarding the pandemic because he does live with elderly parents. We're very much concerned about any exposure he might have taken to those parents. I did have an opportunity to speak with Mr. Waddell earlier today, and he indicated if the case were to be rescheduled, to have Mr. Thomas contact him directly so he could work with him to maybe find an acceptable program for him to participate in. I have also had an opportunity to communicate with Mr. Cox from the District Attorney's Office, and he is not opposed to resetting it, and his text indicates let's reset it. The probation is set to expire September the 24th, so we would ask the court to give us a date, maybe if the court has something on September the 22nd.
I don't have the 22nd available, but I do have September 17th.
17th, that would be good, Your Honor.
Any objection from the state?
No, Your Honor, but if we could get Ms. Dixon to make us aware, how many hours does Mr. Thomas have remaining on community supervision?
I do not know that.
Do you know, Mr. Waddell? That's okay, Mr. Waddell. You can stay here. That issue will need to be figured out by Ms. Dixon and Mr. Thomas anyway, so. All right, court's going to set Mr. Thomas then for a hearing on his motion to adjudicate on Thursday, September 17th.
And will
At
that
9
be
a.m.
9 o'clock, Your Honor?
9 a.m. All right, Mr. Thomas, once you receive that notice of appearance with your setting date, you're free to go, okay? Brandon Smith?
Your Honor, that concludes my business with the excuse.
Yes, Mr. Smith.
Thank you.
Come on up, Mr. Smith. All right, Mr. Smith, I have before the court an amendment to the conditions of your community supervision. And it indicates that you're wanting to have your period of community supervision extended for a period of 1 year. And that would extend your probation period out to August 14th of 2021. And throughout that extension, the amendment would waive the probation fees and UA fees. And you're asking the court to extend your probation today, is that correct?
Yes, sir.
And why are you doing so?
It's because money, I've been out of work the last couple months, last 8 months or so. I have a daughter, a lot of hard, and I'm just behind with money. Yes, sir.
And you believe if the court extends this, that will enable you to be in a better position to comply with your community supervision?
Yes, sir. Yes, sir. No more expecting that, so
And you're doing this of your own free will? No one's pressured you? The probation office hasn't told you you have to do this or anything like that? Is that correct?
yes, sir. I'm doing no more for
All right, court's going to approve the amendment to your community supervision and extend it for a period of 1 year. All right, Mr. Smith, you come over here and meet with Mr. Waddell. We can get you a copy of that and you're free to go. Mr. Biggs, you ready? Yes, sir. Joshua Bailey, CR 20-71. I believe we're set for docket call today, Mr. Biggs.
Yes, sir.
And Ms. Heisel, is the audio better now?
Yes, Your Honor, significantly better.
Good. All right. Sorry about that, Mr. Biggs. Go ahead.
I believe Stacy may have an announcement for you.
Go ahead, Ms. Heisel.
Your Honor, Mr. Biggs has provided Mr. Cox with the results of a polygraph exam. So Mr. Cox is requesting one more docket call to properly examine that and see if it would change the state's offer in any way.
Mr. Biggs, are you available on 17?
I am, Your Honor.
All right, court will set this for an additional docket call on Thursday, September 17th. Once Mr. Bailey has received a copy of his notice of appearance. Here you
Is
go.
that 9 o'clock, Dr. Chair?
9 o'clock, yes, sir. Yes, I'll tell you what, first and last, leave right there and you get the middle two. Josh, that's okay. That's okay. Just Mr. Big, that's okay. Just leave me the yellow.
Sorry, Judge.
It's okay. It's no problem.
I wish I was their lawyer.
Hey, there are bigger problems in the world.
Thank you.
Mr. White, you ready?
Yes, sir.
Is this on Mr. Sorrells or Mr. Tutt?
We'll do
Oscar Tutt, you'll make your way to the podium, please, sir. All right, this is CR 2019, and I see that we're set for pre-trial, and I believe there was a motion to suppress file, is that correct?
I did, Your Honor, I filed one. That motion is going to be a very narrow issue. I'll get with Mr. Cox prior on it and see if we can come to some agreement regarding that. But I would anticipate that particular hearing taking too awful long.
Would you do request the evidentiary?
I did.
All right, court will set Mr. Tutt then for evidentiary docket on October 1st. We could do it sooner on the 27th, but I'm gonna make sure that it stays in that time.
I think for Thursday.
It's on.
Mr. White, I'm here now. Did you, have you filed that motion to suppress yet?
I did.
Okay. You see? Okay. Did you serve it on us?
I believe I sent it to your email and I did serve it.
I just walked in the door. I haven't checked my email yet, but I'll go do that.
Yeah, I'll give you a call on it.
Okay.
All right, so Mr. Tutt, you're set for October 1st. Once you get that notice, you're free to go.
Mr. Tutt?
Oh, Mr. Tutt, can you report to pretrial release? What's the issue? What's the issue? I just didn't have a note on that. Okay, so what we're gonna have you do, Mr. Tutt, is I believe that the court had signed conditions of pretrial release that are attached to your bail. And so you're just gonna meet with them. They're gonna provide you with a copy of those. If you have any questions about those, you can address those with Mr. Waddell. Of course, you can address them with Mr. White. Okay? Have you met with Mr. Sorrells?
Yes.
Are you good to go on that?
Yes.
Okay. Mr. Sorrells, Dustin Sorrells, CR 20-90. I believe we're set for pretrial.
Yes, sir, we are. I had contacted Ms. Heisel very short. I'm going to just a short reset. There's I believe a cat video that I'm going to have to set up with the state to look at. And I'm going to provide Ms. Heisel with some documentation. I don't believe she has an objection.
That's correct, Your Honor. We would not object to another pretrial to resolve those remaining discovery issues.
Then court will reset Mr. Sorrells then for pretrial on Thursday, September 17th. All right, Mr. Sorrells, so make sure that you are in compliance with your pretrial release. If you continue to be delinquent in your payments, and more importantly, if you're not reporting the pretrial release, the court will consider revoking your bail in this case and putting you back in jail.
Yes, Your Honor.
Okay? All right, you're free to go.
Your Honor, I got Mr. Holt this afternoon. I filed a motion to suppress on his case as well. I would have, that may be a little bit longer suppression hearing. That's when I'm gonna have to sit down with Mr. Cox and talk with. I don't know if we'll come to consensus on that one. I have already told my client, I talked with him via telephone earlier in the week and told him what I was doing. Court wants to go ahead and set a date on that right now, rather than having to pull in this afternoon. I'm okay with that. I'm sure he'll call the office, but I've already informed him what I was going to do.
You've already informed me that you filed, wait, let's get on the record on this. So CR 20-A2, State versus Timothy J. Holt, it's set for 1:30 for pretrial, and you've already filed.
Yes, sir. I filed a motion to suppress on Mr. Holt's case. Mr. Holt contacted my office earlier this week. He's in Van Zandt County Justice Center. He contacted my office. I explained to him what I was going to do, that I would sit down and talk with Mr. Cox after I had filed it. We see if we could come to some agreement on kind of what was going to happen, and if not, we would have to go forward on that matter.
All right, so you're asking for your client not to be pulled from the jail and brought before the court?
I think that'd be unnecessary. Yes.
All right, then the court will set this for an evidentiary hearing on October 1st. And Mr. White, you believe that you have all the discovery from the state?
I do, yes, sir.
All right, so Mr. White, I'm going to leave it to you to provide notice to your client of that October 1st session.
I believe that's all I have this morning, Your Honor.
Yes, thank you. Payne, are you ready?
Yes, Your Honor.
Katie Lay, CR 20-132. I believe it's for arraignment today. Is that
Yes,
correct?
yes, Your Honor, we are. My client and I was actually,
Would you do me a favor? Come over here just so that I can get you on camera. There you go.
I was actually unable to make contact with my client until this morning, but we do have a waiver of arraignment.
That's okay. Since she's already here, we'll just go ahead and arraign her on the record. The waiver really serves as a vehicle to keep her from coming to court and you coming to court. So since she's here, you have reviewed the indictment with your client?
I have not had an opportunity to do that. I wasn't sure if she was going to be here today, to be quite honest.
Well, and so the purpose of the waiver of arraignment would also be that she has gone over the indictment, or she'd be entering her plea of not guilty. And if she hadn't reviewed the indictment, then I don't know that she could eligibilely do that. Give me a second and I'll pull up the indictment here. All right, Ms. Lay, if you need to, if you can't see that, it's okay to come closer. Y'all just make sure you maintain your distancing. All right, so right here, I'm having, for the record, I'm having displayed the cause number CR 20-132, State of Texas versus Katie Michelle Lay, State Jail Felony Offensive criminal mischief, 2,500 to 30,000. I'm gonna give you a moment here to review that here. I'll have to make sure names go correctly. All right, and does your client waive the formal reading of the indictment?
Yes, Your Honor, we do.
And is her name spelled correctly?
Yes, Your Honor.
And does she understand what she's charged with?
Yes, Your Honor, she does.
All right, and she enters a plea of, make sure you speak up. All right, court will enter Ms. Lay's plea of not guilty into the record, and we'll set this for pretrial on September 17th. Ms. Kane, have you already received a copy of the discovery from the state?
I have received the discovery, yes, I just haven't gone over it with my clients.
Okay, so of course, the court's policy is in accordance with the code that all pretrial matters need to be raised 7 days prior to the 17th. And what I would be looking for is any motions regarding motions to quash or motions to suppress, anything that's going to require evidentiary hearing or testimony that would be contested.
Yes, Your Honor.
Any type of motion to limine or things like that can be carried to trial.
Yes, Your Honor.
Okay.
Thank you.
All right, and once Ms. Lay gets a copy of the notice of appearance, when she signs that, she'll be free to go. Mr. Waddell, do you have any issues with Ms. Lay?
There should be conditions. And I have no conditions. Because she's the one.
Ms. Lay, have you received a copy of your conditions of pretrial release? You have not? Okay. So I'll tell you, just have a seat and we're going to have someone bring those to you and give you and Ms. Kane an opportunity to look over those. These. Let's just have her sign. Make sure she gets it. Be just a moment, Ms. Lay, and then we'll have you out of here.
Your Honor, how would the court like to proceed on Ms. Hayes' case?
Oh, Mr. Alston, yeah, I understand. If she's not going to be here, then the court's going to call her name, and if she's not here, the court will forfeit her bond and issue a case. I'm sorry, I didn't know you were still there.
It's all right, Judge. I didn't know if you wanted to hear an announcement or not.
No, if she's not here, there's no need for an announcement.
Okay.
Except for arraignment, is that correct?
Yes, Your Honor.
And you didn't file a waiver of arraignment or anything like that, right?
No, Your Honor. I was not able to get that to my client.
All right, so then that's going to be the court's, is Amy Marie Hayes here? Amy Marie Hayes? Yeah, she doesn't appear to be in the courtroom, so I will ensure that notice went out to the correct address, and if so, then the court will forfeit her bond and issue a warrant. So you're free.
Okay, thank you, Your Honor. Have a good afternoon.
You too. All right, Mr. Chambers, you ready, sir?
Yes, Your Honor.
Who would you like to go on first?
Jill Herron.
Ms. Herron? CR 18479, I believe we're set on motion to a vote.
Yes, Your Honor, that's correct. Just, we have an agreement in the case. I talked with Ms. Heisel. Where Ms. Herron will be pleading true to a state jail sentence. And Ms. Heisel was in agreement with resetting this for a couple of weeks if we could reset to August 25th. And then she would plead and then be taken into custody at that point. I don't know if the court recalls, she was in jail back in the spring, was pregnant. She was released, had the baby, I guess, a couple months ago. And then we basically just asked a little more time to get things situated for her child with family. And then she'll come in and do the plea.
Any objection from the state?
No, Your Honor.
All right, we'll set Ms. Herron for plea on August 25th. And will that be for time?
Yes, do we want to do it at the jail?
Yeah, let's set that for 1:30 then. We'll set that for 1:30 that afternoon. You're free to go. Here you go, Mr. Howell.
Yes.
Denny Howell. CR 2029. Mr. Howell set the docket call.
Yes, Your Honor. Judge, I've been dealing with Mr. Cox. I think we reached an agreement this morning, and I was going to see if we could set it for a plea. And on the 25th would work fine if we could. We don't need that much time, but we just weren't going to be able to do it today.
Is it a probation plea or time plea?
It is probation.
Okay. Any objection from the state?
No, Your Honor.
Okay. All right. Court will set Mr. Howell in for plea on August 25th. And once he receives that notice of appearance, he's free to go. Mr. Sanders, I believe that Ms. Taberman has ordered you to investigate.
That's right. That's my understanding.
She's up working on getting a warrant.
Okay, that'd be fine.
CR 20-52, State of Texas versus Willie Joplin. You'll make your way to the podium there, sir. All right, Mr. Joplin, you completed the paperwork and requested a court-appointed attorney. However, you do not meet the financial requirements to be considered indigent.
I didn't know I was, that work for a court attorney.
Yeah,
I
so,
don't feel this out, so I did.
yeah, so you don't meet the financial requirements for a court-appointed attorney. So you have been indicted with the third-degree felony offense of theft of livestock. And so at this point, I need to know, are you going to hire an attorney to represent you?
Yes.
You are.
I
And
thought we was gonna figure this up today, but the fact that we're not, you know, I said to, you know, pay the man out, is the dispute over?
well, let's don't talk about that. And I'll just give you a little bit of a heads up. It's not like JP court. This is felony. You're looking at 2 to 10 in prison.
Okay.
So it's a lot more serious than if you were to go to the JP court and pay a hot check or something like that. So
Yeah.
that's why it's really imperative that you hire an attorney to work this matter out for you because of the circumstances that could take away your freedom.
Yeah, I said,
Okay. So what I'm going to do for you, Mr. Joplin, is I'm going to reset this until September 17th, and that's going to give you a little more than 30 days to go and meet with the attorney or meet with the DA's office or meet with the victim, whatever it is that you feel like you need to do to address this case. That's what you're going to want to do. And, you know, before you go and try to speak with the DA's office, they're going to need to know, are you going to hire an attorney? Because if you are, they're not going to be able to speak with you. All right. So probably the best bet for you is to retain an attorney today and have that attorney reach out to the DA's office and see where they're at on their case, see what information they have. And if y'all can resolve it before the 17th, great. If you can't, then your attorney will come back. We'll make an announcement to the court, and that way your rights are protected as we go forward, okay?
okay.
So what we're gonna do is I'm gonna have my bailiff here give you a notice of appearance. It'll have your name, and it's gonna be reset to September 17th. All right, so this is merely a form that's gonna have a date on there for you to be back, okay? And you'll wanna take a copy of those. She's gonna give you 2 copies. You'll wanna take one of those to the attorney you hired. All right, you're free to go, Mr. Joplin. Ms. Alviso, CR 20-100. All right, the board has reviewed your application for court-appointed attorney, and based on the information provided, you don't meet the requirements under the law for a court-appointed attorney. So what I'm gonna do is I'm gonna reset your case, just like I did for Mr. Joplin. I'm gonna reset that to September 17th, give you time to go and hire an attorney and be back for arraignment on that day, okay? So we're gonna fill out this notice of appearance and then give you that date, and you'll get 2 copies, one for you and then one for the attorney, and then be back on the 17th. All right, there you go. Says William DeCapria. William DeCapria is not here. Billy Fleming. Blake Aaron Hill. Carol Ann Lay. All right, Mr. Nelson. Okay, that's fine. Is Mr. Sanders? Okay, you're gonna go meet with Mr. Sanders. Mr. Pitts, CR 20-89. Mr. Pitts, you've been indicted for prohibited substance or item in a correctional facility. Are you going to hire an attorney to represent you?
Yes, sir.
And how long is it going to take for you to hire an attorney?
I came up with half the money for the retainer fee in like 1 month, so I'm gonna take about 1 month.
Is this your first setting in this court?
Times the second.
This is the second. How much is the retainer fee that you're trying to save up for?
And you said 5,000.
Who is it?
And
Andrew, oh, Mr. Yui?
it's 5,000.
All right, Mr. Pitts, this will be the last time I set you, okay? So the next time you come to court, you have to have an attorney with you. Understand? Court's gonna reset you for arraignment and hire your attorney status on September 17th. So that's a little bit more than a month, so you and Mr. Yui need to come back on that date and be prepared for your arraignment, okay? I don't believe so. Are you on conditions of pretrial release? Have you been reporting and meeting? You know what, Mr. Chris, just go ahead and meet with them just to make sure. I don't have any notes, that you're delinquent or haven't been reporting, but it would be good to check in with them.
Yeah, it was saying come when I go.
Okay, so I'll tell you what, just come over here and you can have a seat. I think Mr. Waddell just walked outside, so as soon as he gets back in, just meet with him. And that way we can ensure that you're in compliance. Can we go ahead and call some names?
Sure.
All right, we will call the following All right, the following names have been called in the courtroom. And their name has been called loudly and distinctly 3 times in the courthouse. No response. The court is going to issue judgment nice eyes and alias capias on the following individuals: Billy Carl Fleming, Jeremy Ron Ward, Amy Marie Hayes, and Don Lee Davis. Ms. Heisel, whenever Mr. Sanders is through speaking with a couple of his new appointments, then the court will come back to recess.
Thank you, Judge.
All right, this is CR 2143, State versus Jose Luis Vela. And Mr. Vela is set for arraignment today. And Mr. Vela requested a court-appointed attorney. The court has reviewed the information provided by Mr. Vela, finds him to be indigent, and has appointed the Honorable Jeff Sanders to represent Mr. Vela. Mr. Sanders, I don't know if you've even had a chance to review the indictment with your client.
Yes, sir, we have, we've looked through the indictment, and his name is spelled correctly, and we would waive the formalities of arraignment, and we enter a plea of not guilty.
All right, thank you, Mr. Sanders. Court will enter Mr. Vela's plea of not guilty into the record. We will set pre-trial for considering the charge. Let's set it a little longer. How about September 29th? Okay. And Mr. Sanders, do you know if Mr. Vela has received a copy of his pre-trial release conditions?
I'm not sure.
Okay, so once you get that notice, you'll need to come back here and meet with Mr. Waddell. Mr. Vela, since Mr. Sanders has been appointed to represent you, there's going to be conditions called pre-trial release conditions that are placed on your bail. It's going to require you to report. It's going to require you to make financial payments towards a court-appointed attorney. It will require you to drug test and pay for that. So those conditions will be provided to you. A violation of those conditions could result in the court revoking your bond and bail in this case, putting you back in jail. Okay, so we're going to get you a copy of those. Once you get that notice of appearance, come over here and have a seat, and we'll bring a copy of those and go over those with you.
And Judge, I was gonna ask, he's 17, he's still in high school. I wasn't sure if that affects anything as far as the fees that had to be paid on pretrial. If that's something that, if there is any possible reduction with that because of his age being still being high school.
I'll have to see what we usually order $10 for the supervision fee per month,
Okay.
and then of course $50 towards your court-appointed attorney fee. So those fees are about as low as they go.
Okay.
Has he already signed? Okay, all right. Okay, thank you. All right, Ms. Taylor has taken those to you. Okay. All right, Mr. Nelson. To the podium, sir. CR 2138, State versus Timothy Robin Nelson. Mr. Nelson requested a court-appointed attorney. Court reviewed that information, found Mr. Nelson to be indigent, and has appointed the Honorable Jeff Sanders to represent Mr. Nelson. Mr. Sanders, have you had an opportunity to present the indictment and review it with your client?
Yes, sir. We have reviewed the indictment. Mr. Nelson's name is spelled correctly. We discussed the punishment range, including briefly the enhancement paragraph, so he understands that it's a charge that's enhanced to a 2 to 20 year punishment range. And then we also talked about his rights to have it read formally in front of the court, but that we would waive the formalities of arraignment, waive the reading of the indictment, and we are not guilty at this time.
Thank you, Mr. Sanders. The court will enter a plea of not guilty into the record for Mr. Nelson. And the court will set this for pretrial on September 29th. Mr. Nelson, have you received a copy of your pretrial release conditions?
Yes, sir.
You have received those? And you've had a chance to go over those and you signed them? Okay, sir. All right, so you're aware of what's required of you and what is associated with your bail in this case?
Yes, sir.
Okay, good. All right, then once you get that, and if you have a copy of those conditions, then you'll be free to go, and we'll see you back on September 29th. If you have any questions about those pretrial release conditions and about when you need to report, you need to see Mr. Waddell if you haven't already.
Yes, sir. I think he has some more paperwork to finish filling out.
Okay, all right, very good. All right, thank you. All right, Ms. Heisel, I believe that concludes this morning's docket. I know we moved pretty quickly. I don't, well, we've been discussing that here, that looks like today largely an arraignment docket, so it went pretty quick. We really had a very good pleas occurring. So those individuals whose names were not, whose cases were not forwarded bail, those individuals already have warrants out for their arrest.
Okay. All right.
Did you get, are there any dates that you need?
I didn't have any dates that I needed. I believe Miss Abney has most of the nice eyes. I have some written down, but we will contact Miss Taberham if we have any questions on the nice eyes.
Okay, I'll tell you what we're going to do on Tanya McBride. She was the one that does not have an attorney. The court received documentation from Longview Regional Hospital that Miss McBride is currently in the hospital, set to have her baby or has had the baby. So we're going to just set her for arraignment, and we'll mail her notice again for September 17th.
Very good, Judge.
Okay. All right. Yeah. If there's anything else that you need, let us know.
Okay, we'll see you this afternoon. Thank you.